You hear a lot of people talking about which assets should be owned by your trust while you're still living. But what you don't hear is which assets not to put into your trust. See, putting the wrong assets into your trust can lead to serious problems. You could trigger unexpected taxes, lose important benefits, or create more hassle than you ever intended. And today, in this video, we're breaking down 5 assets that should almost never be owned by your revocable living trust and why it matters. Hi, I'm Rob, certified financial planner, and this channel is dedicated to helping you get the most ROI out of life and your money. First up, retirement accounts and annuities. That includes traditional IRAs, 401ks, and all types of annuities. These accounts are tax deferred, meaning the money hasn't been taxed yet. And the problem that most people and even many advisors don't realize is that if you transfer the ownership of an IRA or an annuity to your trust, you could trigger a tax disaster. Under Section 408 of the U.S. Tax Code, if the ownership is improperly changed, the IRS treats the entire balance as a taxable distribution. That means a huge tax bill right now. And even worse, if you're under age 59 and a half, you could also face an extra 10% early withdrawal penalty on top of the taxes that would be due. But there is some good news. Since you can easily list named beneficiaries on these types of accounts, you should also be able to easily avoid probate. Here's a few tips. If you have significant retirement assets, and children are still minors, or even adults that aren't financially stable or simply old enough to handle large sums of money, you might name your trust as the beneficiary so those assets are protected and managed responsibly if something happens to you. If your kids are grown and financially stable, you might name them directly as the beneficiaries unless you're expecting to leave a large sum, in which case you could still have your trust named only as the beneficiary. Either way, if you do name your trust as the beneficiary, make sure your estate plan documents include specific retirement account provisions to handle these accounts properly. The bottom line is avoid transferring ownership of retirement accounts to the trust, and just make sure your beneficiary designations are up to date. It's cleaner, it's safer, and for the most part, it avoids the tax trap. Next up, vehicles, boats, and RVs. You can technically name these assets into your trust, but in most cases, you probably shouldn't. Why? Because it can create issues with the DMV, raise red flags with your insurance company, or even void your coverage altogether. And for what? In most states, vehicles of modest value can already skip probate through what's called small estate exceptions. You need to check with your attorney and your state rules, but this is typically the case. But there's a much bigger risk that most people don't consider when they're thinking about transferring these types of assets into their trust. If your trust owns the vehicle and you're in a serious accident and it's your fault, your entire trust, everything in it, could be exposed to that liability. That means a lawsuit over a fender bender could put all of the assets that you worked so hard to protect by putting them into the trust at risk. A better move, use joint ownership or a transfer on death registration if available in your state. That way, your vehicle will still pass to the right people without probate and without the paperwork mess or the added risk of actually having your trust own these assets. And finally, life insurance. There's a ton of confusion around this topic, but generally speaking, Life insurance avoids probate by design as long as your beneficiaries are set up properly. That means naming your spouse, your kids, or other loved ones as beneficiaries directly with the insurance company. When you do that, the money from the life insurance policy will go straight to them. No court, no delay, and no public record. But some people make the mistake of titling life insurance policies in the name of their living trust because they've heard about all sorts of different strategies and tax advantages out there today. But in reality, for most people, having your trust own your life insurance policy just causes unnecessary complications without any added benefits. Doing this could actually reduce the flexibility, lead to administrative headaches, or even open the door to unexpected taxes that you were trying to avoid in the first place. Now, there are advanced cases that you may have heard of where people use irrevocable life insurance trusts, also called ILITs, to keep large death benefits out of their taxable estate. But an irrevocable trust is much different than a revocable living trust, which is what most people have. And unless you're over the federal estate tax exemption, which currently is $14 million per individual or $28 million for a married couple, or live in a state with a very low estate tax threshold, that's probably something that you don't need to worry about. For most families, naming individual beneficiaries or even naming your living trust as the beneficiary without changing ownership of the policy is the best way to go, especially for large policies. Having your trust inherit the life insurance policy can help you maintain control of that money and protect the money from claims, creditors, or divorce after you're gone. Just remember that naming your trust as the beneficiary of the policy is much different than the trust becoming the owner of the policy. And this is the key distinction to keep in mind. Let's recap the 5 assets you should not put into your revocable living trust while you're still alive. IRAs, 401ks and other employer plans, annuities, vehicles, boats, RVs, and life insurance. Trusts are very powerful tools, but knowing what not to have owned by your trust is just as important as knowing what to put into the trust. The reality is that estate planning is a complicated and nuanced topic that is full of hidden traps. And one wrong move could cost you or your family thousands, if not millions of dollars. So don't go at it alone. We offer a free no-pressure consultation to help you and your attorneys get it right. If you're interested to find out more, there's a link down in the description below where you can book a time to chat with us and see how we might be able to work together. We're here to help you protect what matters most. Thanks for joining us today. And before you go, please, if you enjoyed the video, don't forget to hit that subscribe button so you can stay tuned for our latest content.